today's episode, we're navigating the complex legal landscape of dangerous driving offences in New South Wales, spotlighting recent traffic incident that was in Macquarie Park. So discussion isn't just about recounting events, it's exploration of the legal mechanisms at work when a life is lost at the road. So join us while we dissect the charges, the statutes, the broader legal doctrines from this frame case. So those who are passionate about the law and the sort of impact it has, make sure to subscribe for more in-depth legal explorations. So the incident and then initial charges. It's very different when these sort of occurs, but I'll give you a background to the story where it was a quiet suburb in Macquarie Park. A collision occurred at the intersection, bringing us face to face with the harsh realities of road safety and legal accountability. So this particular person was a 20-year-old SUV driver charged with dangerous driving, occasioning death, finding himself into the intersections of legal theory and real-life world consequences. So what does this charge entail, and how does the law approach such serious accusations? Because it's not murder, but it's still a death of someone, and it's not just a summary offence, it's a very serious offence too. But the particular section we're going to look at is called Section 52A of the Crimes Act 1900 New South Wales, which sort of outs of gradation and understanding the driving occasion death. It gives us the elements and it gives us what the court penalty can possibly be in terms of fines and imprisonment. But the statute sort of gives these elements, and the prosecution must prove beyond reasonable doubt that there was the identification of the driver, intoxication, speed, or a matter of driving. But let's not dissect what that means, because the current case law sort of interprets these elements and precedent for what might set the future cases. So in the role of this sort of negligent driving in legal strategy, accompanying sort of these dangerous charges is a very secondary charge to the negligent driving occasion death, which is seen under Section 117 of the Road Transport Act 2013, New South Wales. So it's similar in nature, but it depends what happens on the victim that changes the course for the prosecution course. So the dual charging strategy serves as a multi-phase legal purposes, providing a safety net for prosecution and a complex scenario for defense. But how does this align with the principles of justice and fairness within our legal system? So they consider it as like a backup charge. In legal terms, there's the Form 1. I'll speak about this in another video, but it affects our case overall. But consider sort of the nature of this charge as serious traffic offenders. Does this approach sort of interest into the justice? Does it complicate part of a fair verdict? Share your thoughts below. I love reading them, and I'll try to answer where I can. So let's look into legal defenses. In the sort of shadow charges lies a realm of legal defenses, from necessity to duress to the nuanced argument around self-defense in traffic incidents. So each defense offers very unique lens into which view the accused agent. So case-by-case basis. But how does this defense really argued effectively in court, and what impact would they have on the outcome of such cases? So imagine you're defending a client charged with dangerous driving occasioning death. It's very serious, it's very sad for everyone involved, and especially the victim. But what sort of defense would you consider paramount, and how would you argue that into the case? So leave me your comments, especially on this case. I'd like to see your interesting parts. Again, a case-by-case basis with defenses, but let's speak about the sort of broader nature of this. So as we wrap up this legal journey, it's clear to understand that the incident in Macquarie Park is more than tragic news headline. It's a case that tests the boundaries of legal responsibility, road safety legislation, and the ethical duties of drivers. So with each legal proceedings, a reminder of the law's power to shape the social norms and the paramount of importance to diligence behind the wheel. Courts take it very seriously. I've had people go to jail just for driving without a license. So in the last few years, courts have taken it very seriously, and it's a good thing they do, because it's very dangerous out there on the road. But I'll speak about one of my cases I had about almost 2 years ago. My client, which was my wife's good friend, husband. Essentially what happened is he was working security at night. He'd worked a 12-hour shift, coming back 6 a.m., coming back on the M5, and he didn't realize how tight he was. There was nothing to suggest such dangerous driving except for the tightness, but something you can't test or anything to it. It's a case-by-case basis. But what happened is he unfortunately fell asleep on the wheel on the M5 tunnel, and over there, very small, like it's 2 lanes each side, but there's no real barrier depending on which part of M5 you're in, and subsequently fell asleep, like a micro sleep, and went over and had hit another oncoming car early morning, like I said, 6 a.m. And unfortunately, one of the girls got really interested, that was the driver, and the passenger had subsequently passed away. There was some complications at the hospital, and she eventually passed away. Obviously, it's horrific for everyone, especially those people, because they were backpackers in Australia. So another thing with that as well is my client, he actually was in a coma because he got hit so hard as well, and he suffered a significant brain damage. And he's like, obviously in the years past, he's getting better, but it's never to full capacity. He still has fog memories, and memory overall is really bad, especially short-term memory. It was just a horrific scene overall, and he did eventually get charged, but obviously he didn't go to court for the first time, hence being in the coma and hospital rehabilitation. So the police had sort of the German, and obviously with the defense's consent, but upon reviewing further brief material, he looks like the passenger didn't have a seatbelt, which is not to excuse his behavior or anything to it, but it's just giving you insight. And obviously the prosecution and the court took that into account, but nevertheless he still pleaded guilty in the first instance. But that's where the importance of a proper legal defense, because you get all the subjective material, you bring it to the court, what happened to him as well. So there's a lot of principles in sentencing, and one of them especially is the risk of reoffending, rehabilitation, prospects of success, and a number of other things. But also there's this thing as well, and it's very crucial at this point, was what's called extracurricular punishment. So generally speaking, in this principle, what happens is the offender is not to be punished further than by the court. So in this case, where he was obviously in a coma, has suffered brain damage, he's never going to be 100% capacity. The court had taken that into account, so his responsibility and the extracurricular punishment kicked in, so he had short-term, it's not gone. There still needs to be a case heard for that. And we got it to argue, and we got very strong objectives. We got medical reports, we got psychologist reports, and obviously case law. We wrote submissions to the court, and we were able to get him a intensive corrections order, which is essentially the alternative to imprisonment. It's the last alternative, where it's kind of like home detention, depending on type of condition. But one of them was obviously he lost his license, of course, and the other thing was continue with his treatment, undergo psychological value, and a lot of other conditions. But it was just a very sad case overall. But it's one of those things where, like I always say, it's very important to get legal advice. Like, again, I say this almost in every video, but almost every criminal law firm has a free consultation. Call them, call legal aid, call anyone. They will give you general advice over the phone, and at least you get a better understanding. It's completely free. Just do it. There's no obligation to do it, and you can just call a few places to get a few different ideas. That's the whole purpose of us being there. So I hope this video helps, and I hope to give some insight. And if you're charged with something like that, call a lawyer or call legal aid to get proper advice. Don't just follow what the prosecution says with everything. Thank you for your comments, and hope you enjoyed this video. So we're going to Arthur Smith 2014 NTSC 19. Which dives into the sort of intentions behind demand, and also the use of menaces, offering clarity on the elements that need to prove such a crime. Again, South Australia, under Section 172 of the Criminal Law Consolidation Act 1935, and the Western Australia's Section 397 of the Criminal Code, each providing very similar frameworks for these offences. There was a particular case versus Arts vs Tenery 1997 SASC 6163 in South Australia, where it showcases how these threats of property or gain to legally navigated, reflecting the spectrum of actions deemed criminal under these laws. This whole exploration of the laws into blackmail extortion across Australia unveils sort of this nuanced legal interpretations, but overall you can see the similar nature and just trying to define and what it means, how can it affect someone, and what do you benefit gain. So if you're intrigued about the legal system that tackles these sort of complex issues, like and subscribe and engage with us in a comment, share your thoughts and discussion, and stay tuned for more legal insights on Lawishhh. Thank you.